If you can't see what that court is doing, it's hard to actually get any meaningful sense of legitimacy or trust from the existence of that court.
I'm Justin Silverman of the New England First Amendment Coalition. As we near the end of our spring fundraiser, I want to ask all of you to support NEFAC by making a donation at NEFAC.org. We're directly addressing problems facing citizens and newsrooms throughout the region. Here are some examples. In January, we recently launched our 30-minute skills classes to give short, practical lessons on topics such as data cleaning, health reporting, and how to stay safe as a journalist. We're testifying on your behalf to make sure that state legislatures continue to allow broad, public, and remote access to government meetings post-pandemic. We're providing webinars on state public record laws and the Federal Freedom of Information Act, all available to you at no cost. But we need your help to continue this programming. We need your help to keep the momentum toward a more open government and more protections for our First Amendment freedoms. So please make a donation right now at NEFAC.org. Thank you. I'm here today with Maddie Lamo, a media litigation fellow at the Reporters Committee for Freedom of the Press. Maddie and her colleagues recently submitted an amicus brief on behalf of NEFAC and other media organizations, arguing that certain secret court records should be made public. Maddie, thank you for joining us.
Thanks for having me.
Before we get to this particular case, Maddie's going to first tell us about secret courts. And for everybody listening, you heard that right. Secret courts exist in this country. So forget about the presumption of openness or the First Amendment right of access. In some cases, there are courts that operate entirely in secret. Maddie, how's this possible?
So these courts, it's really just one court, and then it has its own special reviewing appellate court. So these two courts, which I'll call the FISA courts, were created when Congress passed the Foreign Intelligence Surveillance Act, or FISA, in 1978. And that act was passed after Congress and the public learned about an assortment of different intelligence abuses that had taken place throughout the 60s, 70s, and even in the decades prior. So those included things like the FBI and CIA had programs. For example, one was called COINTELPRO, another was called Minaret, and those involved spying on citizens without a warrant, basically just for engaging in protected First Amendment political dissent type activity. So for example, there was a lot of spying on anti-Vietnam War protesters and on the Black Panther Party. Also, the Nixon White House engaged in extensive abuses of its intelligence power as sort of the head of the executive branch. So after all this kind of came to light in the early 1970s, there were a series of Senate committee hearings, the Church Committee hearings, they were called, and that ultimately culminated in the passage of FISA with the goal of increasing the sort of checks that were implemented when the executive branch engages in foreign intelligence surveillance. And one of those checks was the creation of the FISA court. So in ordinary law enforcement, when, say, the police or federal law enforcement want to get a warrant to conduct some kind of search, they will write an application and they'll submit that to a judge who will then sign off on it if it meets certain standards. What the FISA court initially did was basically that type of thing, but in the foreign intelligence surveillance context. So if foreign intelligence surveillance organizations wanted to conduct some type of search in the interest of foreign intelligence, they would submit their application to the FISA court, who would then approve or maybe modify that search application. Over time, however, the sort of breadth of what was coming before the FISA court expanded. This was a result of a couple different things. One is just evolving technology. So as technology became more advanced and it became more and more integrated into our everyday lives, it became possible for the government to conduct much broader surveillance through our emails, telephone records, computers, everything. And also after 9/11, the executive branch's surveillance powers increased pursuant to different statutory schemes. So then the executive investigate the like intelligence agencies would go to the FISA court and say, you know, hey, under this new provision of, say, the Patriot Act or whatever, we think we can do this type of bulk data collection. Does that sound okay? And the FISA court would say yes or no. And in many instances, it looks like they said yes. So all of this was happening completely in secret. People would not know, even, not only were people not understanding what type of searches and surveillance were being conducted, but they also weren't learning what the rules were, sort of what the boundaries were of permissible surveillance activity by the federal government. And so this case is really important because the petitioners, the people asking the Supreme Court to take the case, are asking for an avenue for the public and the press to seek access to decisions of this court, which will allow the public to better understand what rules the government is even playing by when it conducts foreign surveillance.
Right. So let's get back to the history of these courts for just a moment, because they were set up as, or they were intended to be a check on government power. But because they're operating entirely in secrecy, you know, can you spell out for us clearly, what is the danger there to the public?
There's a couple different dangers. One, I think, is that while judges are generally pretty smart and have a lot of, you know, wisdom, they don't know everything and they don't think of everything. And one of the benefits of open courts is that members of the public can raise concerns that parties before a court may not raise and a judge may not think of. And that's especially true. The FISA court, it's not an adversarial system where one person is suing another one and everyone is bringing their best arguments against each other. It's just a one-party court where the government comes in and says, we want a warrant to do this, or we want to be able to conduct this type of search. And with no adversarial briefing, the court says yes or no. So concerns about, you know, privacy, free speech, you know, chilling open discourse or other types of civil liberties concerns, as well as concerns about, you know, how does this type of technology actually work? Those concerns just can't be raised as if the government doesn't bring them up and the judge who's reviewing the application doesn't think of them independently, which he or she may not have reason to. So public oversight allows really important concerns to be raised by experts. That could be academic scholars or civil liberties organizations or so many other people who really understand these issues deeply. And if they learn about what the court has, either the issues before it or the decisions that it has issued, they can say, like, hold on a minute, this raises, you know, X, Y, and Z concerns. There's also components of public trust. When people understand what the government is doing, even broadly, even just sort of what rules it's playing by, that can help people understand, you know, the government has surveillance authority, that's part of its job, but it's going to follow these rules, and there's a court set up to actually hold it to those rules. But if you can't see what that court is doing, it's hard to actually get any meaningful sense of legitimacy or trust from the existence of that court. Otherwise, it has a very sort of behind closed doors, you know, a lack of transparency can make people feel like there's not really any accountability at all.
And to be clear, as these FISA courts currently operate, is there any oversight at all, even after the fact? Can we get any information about these decisions the courts are making?
The court can now, as of fairly recently, it has the authority to, of its own accord, release certain of its decisions. Those are only, I think those are only decisions that are from 2016 or more recent. And the records being sought in this case predate that change. But that's still completely the decision. I think it's a decision maybe by executive branch officials and or members of the court. So it's not in response to a request from the public, it's just a unilateral internal decision. So it doesn't do much, in my opinion, to improve public trust when a court is only releasing the decisions that the government has decided the public should see.
Got it. So now let's get back to this case where you and your colleagues filed the amicus brief, a great brief addressing a number of concerns about the secrecy. The case is ACLU v. United States. Tell us again, Maddie, if you could, what particular documents are being asked for by amici here?
So This case involves, as I mentioned, it involves records from a specific time period. So I believe it was post 9/11 up through, I actually don't remember the exact end date, but I think it's around 2015 or 2016 before that change was made. And specifically, the ACLU and its co-petitioners are seeking access to significant opinions and orders of the FISA court that contain, I think, novel or significant interpretations of law. So what that doesn't include would be like a one-off warrant decision, but it would include things like, for example, something that this specifically has now been made public through another means. Edward Snowden leaked information about the bulk telephonic metadata practices that the NSA was conducting for many years. That was a program that was approved by the FISA court. So those broad decisions saying this provision of the statute allows a particular agency to conduct a certain type of surveillance activity, you can do this type of thing. Those are the decisions that we're asking for, or that the petitioners are asking for here, and we're supporting that request.
And what type of arguments is the government in this case making in favor of them being kept secret and withheld from the public?
So there's a few different arguments being raised. One, of course, is that this is national security and this is just too sensitive and it will hinder the government's national security efforts if this kind of thing is being disclosed to the public. Another is actually a more technical sort of statutory interpretation argument, which is that the FISA court, which is, as I mentioned, it was created by a statute, the Foreign Intelligence Surveillance Act, that it does not have the jurisdiction or the authority to even hear motions from the public seeking access to its own decisions, which is a really, it sounds weird and it is weird. It's a sort of crazy argument. Courts generally have authority to sort of, we call it supervisory authority over their own records and files, but they've made this sort of convoluted argument saying, because we can only hear specific types of warrant applications from the government, we can't hear any other sort of motion from members of the public. So that's actually this really critical threshold issue in this case, and it's sort of a legal nerd thing, but the threshold issue is whether the FISA courts even have the authority to hear these access motions. So we argue, of course, that they do, and we argue further that the court should then find that there is a public right of access to its opinions and orders.
Wow. So to put it very simply, government's arguing on one hand, not only should these records be secret, but you members of the public don't even have the legal right to ask for them.
Exactly. Yeah. And that's an argument we described as if their decision would left standing, it would close the courthouse door on members of the public who are just trying to seek access to these really important court decisions.
So where do we go from here? What are the next steps in this case?
So this amicus brief was filed in support of a petition for a writ of certiorari, which is a really fancy way of just saying that we're asking the Supreme Court to agree to take the case, because the Supreme Court only hears a very small number of the cases that people ask it to hear every year. So fingers crossed the court will agree to take the case. Hopefully it will recognize how important this is. If they do agree to take the case, then there will be briefing by the parties, many more amicus briefs, I'm sure. If they don't agree to take the case, that I'm not sure what the next step is. That may be sort of the end of the road. I don't know. There may be other avenues to pursue, but hopefully the next step will be review of this issue or these sort of interrelated issues by the US Supreme Court.
Maddie, thank you for all your help walking us through all of these issues. Some of them, very technical. I appreciate you helping us understand what's going on here and what the consequences of this case could be.
Thanks for having me, and thanks for joining our brief.